When does a child have a say in custody decisions? What should you expect with respect to that say? Well, my name is Goldman, and I'm an attorney with Goldman and Associates. I'm the firm's founder and director. Our firm has a primary focus on family law issues here in Michigan, and today we're continuing our video series designed to educate and inform the public, so please subscribe to our channel. Well, a child does have a say. Typically, that say is addressed when the child is 12 years old, maybe older, and the court will ask the child and determine what the expressed preference of the child is with respect to custody. You want to live with your mom? You want to live with your dad? Now, you have to understand how it works. The court will not generally put a child on the stand and have that child testify in front of both parents. I'd rather live with mom. I'd rather live with dad. The court's not going to put anybody in that position. Oftentimes, the court will sit the child down in camera, which means in the court's chambers, and in a private discussion, ask the child if he or she has a preference. And the court will not tell the parties what the preference was. As the court goes through the analysis of what's the best interest in the child, when the court gets to the one that's called express preference of the minor child, the court will indicate, I've had a discussion with the child in chambers. The child has expressed a preference to me, and I will take that into consideration. And that's it. The court won't reveal who it is because, again, what would be the point? It would just put the child in a bad position again. So if your child is of age, the court may very well ask the child what the preference is. Now, remember one thing. Even though the court can and at times will ask the child to determine what the child's preference is, it doesn't mean that that's going to carry the day any more so than if your kid tells you, I prefer not to go to school. You know what? You can prefer all you want. When you're, making your own living out as an adult, God bless you. But when you're in my house, you go to school. Parents make that speech all the time. So the things like this, the child can express that preference. But remember, there's about a dozen factors that the court uses to determine what's in the best interest of the minor child. And the preference of the child is at most 1 out of 12. So even though it's important and all the factors can be weighed differently, and I can envision situations where that may be a heavily weighted factor, it is 1 out of 12. And in most cases, other factors may well carry the day when the court is making the overall analysis. If you have any questions about that, reach out and we'll be glad to help you out.